It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt. This is the Sunday edition. As you know, there's a Saturday edition also, so if you haven't heard me talk on the radio on Saturday, please tune in at 11 o'clock in the morning on 9:30 a.m. The Answer or 6:30 a.m. The Word here in San Antonio, Texas. If you're listening on podcast or YouTube, just know that there's more episodes that you can access. Just go to talklawradio.com. You can search for archived episodes there. Search for the legal terms that you're interested in learning about, and you can find more. Also, send me some feedback about what you're interested in by emailing me at host@talklawradio.com. That's HOST@talklawradio.com. Today is going to be a great show, as you know. Last week, I talked about the codification of the Texas Business Judgment Rule, and today I'm going to talk about some other new Texas laws that have been codified. So this is your 2025 legislative update as it relates to Texas business law. So this law became effective, many of these laws, let me be clear, became effective May 14th, 2025, and directors, officers, and shareholders need to know about this. So listen up. But before we get started talking about the law, let's begin with prayer. Dear God, thank you for this day. Thank you for the gifts and blessings that you give to us. Please forgive us for our sins, for our mistakes, for doing the wrong thing or failing to follow your will. Please help me give good information about the Texas Business Legislative Update today. Help us to use the gifts and talents that you've given us for the good of your people, for our own good, and for your glory. In Jesus' name, amen. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. And like I said, we're talking about the Business Legislative Update. Texas legislature just finished its regular session, and it's right in the middle of a special session, but we're not going to talk about that. We're going to talk about laws that actually did pass the Texas House and the Texas Senate and were signed by the governor. So today's hidden legal issue is business law, and especially companies that are regulated by the SEC. They're on an exchange and they're publicly traded, or it could be a smaller business that's not publicly traded, or it could be a private business that's big or small. There are several legislative changes that allow you to change the way your business operates so that it's more difficult for shareholders to file suits against officers and directors. And so this also affects shareholders because it can be frustrating when you're invested in a company that's not running the way that you want to. So stay tuned. Also, you should be aware that Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, tax-protected inheritance plans, also corporations and contracts, LLCs, family limited partnerships, and we can help those who are facing problems from lack of planning, like in district court, county court, or probate court. Back to the issue at hand, the Texas legislature has these new business laws, and some of them are regarding business-friendly governance, and that's just a general term. And what the governor and the legislators wanted to accomplish by passing this series of laws was to make it more attractive for businesses to have their legal entity filed in the state of Texas and to possibly have their headquarters here, have their officers and directors here to help create new jobs and to spur the economy. Okay, let's get into it. A lot of these laws were packaged under Senate Bill 29. And so it deals with formation, governance, internal management of domestic entities. In plain language, it changes some of the rules for how Texas businesses like corporations, LLCs, and partnerships run. One of those things is the waiver of jury trials. Now, if you're a sophisticated business owner or even a sophisticated business person who does business on behalf of a company or on behalf of yourself, you've probably seen this already in a contract before where you want to get the agreement of the other party, the supplier, the manufacturer, the salesperson, whoever, that you want them to waive their right to a trial by jury. Now, why would anybody want to waive the right to a trial by jury? Well, the answer is to save time and money. It takes a long time to get to a jury trial. You have to prove everything with evidence. There's rules of evidence that attorneys have to follow. Not everything that you think is evidence will make its way in front of the judge or the jury. Everything has to be introduced as evidence in a specific way, and some evidence is not going to be let in. The jury may not be allowed to consider it because of whatever type of evidence it is. That's another show. Also, there's rules of civil procedure about how to request evidence, about what types of evidence are appropriate for different kinds of cases. And so all of these barriers make it time-consuming and expensive to get through a jury trial. Now, why would it be expensive? Because you have to pay your attorney to follow all of these rules, to package the evidence in a certain way, to introduce it in a certain way. And if you can avoid the jury trial by going to mediation or arbitration, both of those things fall under something we call alternative dispute resolution. It can resolve disputes faster and with less cost. Now, we know that disputes are going to happen, right? Because the first dispute was when Adam and Eve ate the fruit of the forbidden fruit. Forgive me. So ever since then, we've been born into sin. And thank goodness Jesus came down and sacrificed himself, died on the cross, and rose again to bring us new life. While we live here on earth at this time, we have to live in the world, even though we're not of the world. But even good people, Christians or otherwise, are going to have disputes about the way the company's running. We know that. But these laws are here to make it easier for business. And so if you're an investor or a shareholder, you're going to have to get more sophisticated. You're going to have to get more help to decide whether you want to invest in this business or that. So that there's a waiver of jury trials. There's also a new rule that's codified that explains when shareholders are going to be allowed to get the corporate records. Shareholders that want to see the corporation's records must state a proper purpose. And the rules are now more clear about what defines records. Emails, text messages, and social media communications are not generally included. So you can probably imagine a scenario where a disgruntled shareholder wants to harass one of the officers or directors and asks for all of their emails. Well, that they have to have a proper purpose. They have to be able to state that, and they're not going to get access unless they do. And so this protects officers and directors, just like I said before, and could frustrate shareholders a little bit. Now, most of this comes about in what we call a derivative suit. And I explained this last Sunday. It's when the shareholders want to sue on behalf of the corporation. They want the corporation to sue the officers and directors, but who runs the corporation? Officers and directors. So the shareholders go to court and they ask the judge, we'd like to represent the corporation and file a lawsuit against the officers and directors for some sort of wrongdoing. That's what a derivative lawsuit is. And that's where a lot of this comes into play. You know, because you've been listening to the show, or maybe you didn't know because you're just listening for the first time today. You're just jumping in the middle of my program. Texas laws allow directors and officers to be protected by the company with these new laws. Now, I keep saying new laws because it's now codified. It's now written into the statutes. In the past, these things may have been allowed, but they were judge-written rules. They were opinions and decisions by the court rather than being written on the books. And so what the Texas governor and the legislature figured is that business people would feel more comfortable about organizing their business entity in Texas, bringing their headquarters to Texas, if these common law rules were actually written into the code to let everybody know what to expect. And I told you before that the Talk Law Radio is sponsored by Marquardt Law Firm. Just want to remind you, as you continue to develop and grow your business, it's crucial to ensure that your business structure provides the protection and flexibility you need. I'm here to help. To assist you in this endeavor, I recommend conducting a self-analysis using what I call the Business Deficiencies Checklist. This tool will help identify potential areas of concern that may require legal attention. The checklist includes questions about your formation date of your entity, the location of formation, concerns about the strength of your business structure, and considerations for personal and business asset protection. If any of your answers on the Business Deficiencies Checklist cause you uncertainty, it may be beneficial to consult with a business attorney. A business attorney can advise you on whether amendments to your certificate of formation, operating agreement, or bylaws could be enhanced to limit your liability in the company as an officer or director. And attorneys at Marquardt Law Firm focus on business and estate law, including contracts, corporations, LLCs, and family limited partnerships. How do you get the Business Deficiencies Checklist? It's easy. Email welcome@marquardtlawfirm.com. That's welcome at M as in mother, ARQUAR, D as in David, T as in Timothy, lawfirm.com. Type in the subject line, business checklist, and we will reply with the checklist attached. We look forward to assisting you in strengthening your business structure and ensuring your LLC or corporation provides the protection you require. Back to the program. Parts of Senate Bill 29 are making Texas more attractive for businesses to form their legal entity here, to organize their business in Texas, and to possibly or potentially bring their headquarters to Texas so that these codified statutes about business law and about how to protect officers and directors will make them more comfortable about being here. There's a whole long list of things that I need to talk to you about, and so I'm going to talk as fast as I can. Last week, I talked about the codification of the business judgment rule. If you missed it, just go to podcasts anywhere you listen, search for Talk Law Radio, and find the episode about the business judgment rule. Or go to YouTube, search for Talk Law Radio, and look for the Lady Justice and the red, white, and blue logo. While you're there watching my video on business judgment rule, click subscribe so that you can receive an alert every time that a new episode is posted to YouTube. There's a new statute about derivative shareholder litigation reform. Just a couple of minutes ago, I was defining what derivative litigation was, and you're probably wondering, why does it need to be reformed? Well, it needs to be reformed because the officers and directors of companies never know when a shareholder is going to become disgruntled. Last week, I talked about a scenario where maybe one of the shareholders aligns themselves with some fringe political interest group. Well, I have a real-world example of when this happened. Do you remember when Elon Musk got involved in a lawsuit and the shareholders were upset about how much he was being paid? That was a derivative lawsuit, and it was filed in Delaware because that's where Tesla was organized. That's where their legal entity was filed. And the shareholder did not even own very much of the company. It says Richard Tornetta, who owned just 9 shares of Tesla, successfully challenged Elon Musk's $56 billion compensation package. Well, thank goodness for Texas Senate Bill 29, enacted May 14th, 2025. Now in Texas, publicly traded companies or those who opt in can impose a minimum ownership threshold of up to 3% of outstanding shares for a shareholder to initiate a derivative lawsuit. This requires only those shareholders with skin in the game to be able to complain about what the officers and directors are doing. So that limits the number of people that are going to be filing derivative lawsuits complaining to the officers and directors. If you want to have a voice in the company, you're going to have to own lots of the company. 3% is quite a chunk of Tesla, because there's not that many people that can own 3%. You can do the math. So while groups of shareholders can band together to meet the 3% threshold under Texas law, the logistical and coordination challenges of rallying enough shareholders to meet this requirement could still deter such lawsuits. So that makes it more favorable in Texas. Let's go back to another new statute. Another thing that's codified that attorneys have been putting in contracts for years is to choose the forum and venue. Those are legal words that mean picking the type of court and picking the location of the court. And now in Texas, a company could put in their company agreement that they want all of these disagreements filed in the state of Texas. You don't want somebody from California filing a lawsuit in California just because they happen to be a shareholder in California and dragging all of the officers and directors to defend themselves in California. That's an additional expense. That takes a lot of time. And the laws of California may not or the courts of California may not apply the laws of the state of Texas. That's a whole nother show about comedy. Not the funny kind. There's this other legal word, comity, that is about which laws of which state you're going to apply in any specific dispute. Something new that Texas came up with a year or so ago is a Texas Business Court. So it's a special court with a highly trained judge who has lots of experience in business law to hear only business disputes. So you don't have some divorce attorney that's trying to figure out what the right business law to apply is. We talked about waiver of business trials, and another new definition is the internal entity claim. This is important because this phrase is going to be used in lots of the different laws that are being codified. An internal entity claim means a claim of any nature, including a derivative claim in the right of an entity that is based on, arises from, or relates to the internal affairs of the entity. So internal affairs, let's define that also. It includes the rights, powers, and duties of its governing authority, governing persons, officers, owners, and members, and matters relating to its membership or ownership interests. So that's the thing that ties all of these statutes together that are being codified, is we could put them under the umbrella of internal affairs and internal entity claims. It's, like I said before, suits by shareholders against officers and directors because they're upset about how the company is being run. Well, not everything that makes you upset if you're a shareholder is a lawsuit that needs to happen. When you bought shares in the company, you knew that other people were going to be running the company, and you don't get to decide everything. You rely on them to run the company in the best way possible. And if you don't know those people, you need to do some research about how the company has been run. What are their strategic plans for how the company is going to be run in the future? It's a risk to invest and own shares in another company that you can't control, isn't it? Sometimes that risk pays off and the value of your shares grow, and then you can sell your shares at a higher price and make a profit. But it's a risk that you take on. And so make sure that you have a business attorney, make sure you have an accountant, make sure you have financial planners that are there to give you advice about whether or not you should do this. Here's another rule that's been codified. The Business Organizations Code is amended to read as follows: on written demand, stating a proper purpose, a holder of shares of a corporation for at least 6 months immediately preceding the holder's demand, or a holder of at least 5% of all the outstanding shares of a corporation, is entitled to examine and copy at a reasonable time the books, records, minutes, transfer records, other records. But for the purpose of this subsection, the records of the corporation shall not include emails, text messages, or similar electronic communications or information from social media accounts unless the particular email communication or social media information effectuates an action by the corporation. Well, I'm going to have to end the show. There's a lot more that we can talk about, but the main point that you should learn from hearing me today is that if you own a business, or if you're an officer or a director, or if you're a shareholder, now is the time to ask for a copy of the formation documents. Ask for a copy of the bylaws or operating agreement so that you can read it and compare it against these new laws and see what's what. because things can change. You can increase the level of protection that you get. Or if you're a shareholder, you might lose some of the rights that you once had. Well, remember to email Marquardt Law Firm, welcome@marquardtlawfirm.com, to ask for your business deficiencies checklist. Tune in to Talk Law Radio, YouTube, Facebook, and talklawradio.com. I'll talk to you later.